It's such an honor to introduce you all to Attorney General Sam Olens. I have known Sam personally ever since I was on the editorial board at the Atlanta Journal-Constitution, and you can read Sam's bio on the agenda in front of you, and I'm not going to tell you about that. I'm going to tell you two things about Sam. No, three. Make that three. First of all, he's from Cobb County, and when Sam was commission chair in Cobb County, it was my favorite place to live. I still live there, though. Second, this is Sunshine Week in Georgia, and that is all about government transparency and the ability for taxpayers and voters to see what's going on with government. And Sam is personally responsible for the overhaul of Georgia's sunshine laws in 2012. So this is very serendipitous for us. And the third thing that I want to tell you about Sam is that no matter where he is, he will return your phone call. Before you leave, ask him for his cell phone number. He gets back to you. I reached Sam once in New York on a plane. He was on his way to Israel. He got back to me and told me who I needed to talk to. So it is such an honor to have such a great public servant to speak to us today on federalism and regulatory access. He's lived it, he works it, and he is our state's legal eagle.
She was going to call me the legal beagle, so I'm really happy it's changed to legal eagle. So it's a pleasure to be here. So afterwards I'll be happy to give any and all of you my phone number, but not with the camera. There are limitations at that point. So it's a pleasure to be here. I haven't yet figured out how you ever tell Benita no, so that's why I said yes at that point. And I do want to introduce one person who's here. Where's Timothy Butler? So stand up. So Timothy is our new policy director. So you all might want to meet Timothy. Britt was the prior policy director, Britt Grant. She's now Solicitor General. So we're creating a new conspiracy in the office. We now have 2 law school graduates from Stanford University that are active with the Federalist Society, which means there's 3 more in recorded history. So 2 of them are in our office, and Timothy does a great job. So I thought I would talk a little bit about federalism, and this works really well because actually Friday I'll be at the National Press Club for a program celebrating the 30th anniversary of the Republican National Lawyers Association. So they've got a whole bunch of speakers. Somehow or another, senators are actually spending the night in D.C. Thursday to stay there Friday for that program. So that will be really neat. So I appreciate Kelly and Benita inviting me to come here today. It's on my way to work, so that works out really, really well. At that point, pass here every day. You know, if you look at the Constitution, something that I really wish more people in Washington paid attention to, it was written to secure the blessings of liberty to Americans. And it is a safeguard against tyranny. And of course, many of you are familiar with the famous quote by Patrick Henry: the Constitution is not an instrument for the government to restrain the people, it is an instrument for the people to restrain the government, lest it come to dominate our lives and interest, and we're missing that. In fact, we're now living in a time where everyone seems to solely be concerned with the ends rather than the means, and it's all about the immediate political agenda rather than the long-term effect it has on our country and the rule of law. So clearly the Constitution is important in limiting government and providing liberty in numerous ways. We're of course familiar with the enumerated powers. We often talk about the fact that you look at the Constitution, you look for the role of the federal government, the rest belongs to the states. Clearly you've got the Bill of Rights, so you've got the enumerated freedoms of the Constitution. And we know that the Bill of Rights is very special because most constitutions, once again, give power to the government, whereas our Bill of Rights gives power to the people. So that's very important. And we know that the structure of the Constitution is really very important. The first 4 articles that talk about the separation of powers, the role of the federal government, the 10th Amendment that clearly deals with the ability, once again, for the people and the states to have authority that isn't expressly given to the federal government. And then we also know about the systems of checks and balances, and y'all are very familiar with that. But we don't pay enough attention to those, the idea of sovereignty, of dual sovereignty or federalism. That not only is there the checks and balances with the federal government, but there's the checks and balances between the federal and state governments. And this administration in particular seems to be taking away the authority that traditionally rested with the states. So as an example, when we talk about cooperative federalism, the EPA was created to set standards and it was left to the states to get us there. More and more, the EPA is not approving state SIPs, state implementation plans, and telling us, we will tell you not only what you need to do, but how you need to get there, which is 100% wrong based on the intent of many acts of Congress, but also wrong with the system that created our government, the Constitution. But of course you know this, but it's important to remind people about the dual sovereignty because they often forget that there actually is a role for the state or the states, and that it is appropriate for those checks and balances to occur. So with President Obama, it's no surprise that the conservative attorneys general are more active than ever. All you got to do, there's some great articles in the Weekly Standard that talk about the work we've done. Candidly, don't expect me to be very positive about Congress because Congress, frankly, has done very little. And I predict over the next year and a half we'll do very little to check the president. And it's really been the attorneys general who have been the most successful in this effort. We don't win everything, but we're winning a lot. And sometimes the public may perceive as a little win, but actually ends up being a big win from the courts. So we're clearly going to the courts. We're clearly providing massive amounts of content for the rules. We're clearly spending more and more time on what the residents of our country spend too little time on, and that is what's sometimes actually called the fourth branch of government, called the regulatory agencies. You know, clearly when Congress passed the Affordable Care Act, Dodd-Frank, we were involved in it. We're waiting for the decision from the D.C. Circuit Court on Dodd-Frank. We're one of 11 states there. But we really spend more time dealing with the acts of the executive agencies than we deal with the acts of Congress, because Congress generally names post offices more than they pass real bills. So we spend more time with the regulatory agencies. If you look at a site, I just looked earlier this morning, regulations.gov, among other things that it tells you is the number of regs where comments are to be finalized and back in the agency in the next 90 days, along with regulations that have just been brought out in the last 90 days. So while people tease the president about going to a golf course, let me tell you, his agencies are working in fifth gear. So if you look at regulations.gov, the number of proposed rules or regulations that are due in the next 90 days is approximately 1,000. The number of rules or regulations that have been promulgated, that have been initiated, not promulgated, that would be finalized, but initiated in the last 90 days is closer to 6,000. So here we are, March 15. There's a lot of work that's going to occur between now and January 17. A lot more regs. Several of you in this room are involved in the energy space. There's a lot more coming your way, as you know. So I wanted to talk about federal overreach, wanted to talk about a couple cases we're involved in. Clearly Timothy's very involved in them, along with Britt at our office, where attorneys general grouped together, because none of us have adequate resources to take on the federal government. We've all got to work together and do the best we can in that regard. So the first suit I'll talk about, following, of course, the Affordable Care Act case where the majority of states were involved, the National Federation of Independent versus Civilians case that we want to talk about is the case that everyone was surprised the Supreme Court took up, which was the King versus Burwell case. Because when you think about it, there was no split of opinion. There was no circuit split. So many people were very surprised that the Supreme Court took this case up. There was no automatic need to take it up. It wasn't like the Sebelius case, the NFIB case. And while the public doesn't understand that the administration claimed that the ACA was constitutional based on the Commerce Clause, and we actually won on that theory, all the public knows is that we lost because Chief Justice Roberts decided it was tax and spend, even though the administration told us it wasn't tax and spend. And they do sort of know that we won on the coercion argument with the expansion of Medicaid. But once again, when you only look at the ends rather than the means, we're just the evil folks that didn't want everyone to get insurance. I happen to want a pre-existing clause. I happen to want insurance to be accessible and affordable. But the thing that gets in the way is I actually want it to be done legally, which seems to not really attract press attention in that regard. So the King versus Burwell case literally takes up one phrase in the law that says that you have to have a state exchange to have the subsidy. Now, for all the folks like Jay Bookman who said, well, clearly that was just, a mistake. No, it wasn't, because the earlier versions of the act said state or federal. It was the final version of the act that literally said state, which was once again coercion, where the administration was saying, you've got to get a state exchange, because if you don't, you won't have the ability to do the subsidy. So they were pushing the states to do it. And oh, by the way, that famous professor from New England has in fact told us on one of his many famous tapes now that it was intentionally done that way, Gruber. So there was no mistake here. It was very intentional. And you had a very interesting discussion in the Supreme Court recently, I believe March 3, where you had the liberal justices led by Justice Kagan saying, well, clearly you need to look at the body as a whole rather than the particular words at play, which is actually something very different than my alma mater taught me. And then you had the other school of thought that words actually matter, and when you put words together in a bill, you're actually supposed to follow the wording of the bill. So it will be very, very interesting watching this, because this will be a classic set of opinions in the U.S. Supreme Court on how you define that type of discussion. The result, of course, will be huge either way. While there still are cases with regard to the origination clause, a couple other cases out there, this case will really determine in large part the president's legacy on health care. This case will determine whether or not we're going to have massive deficits in it, a policy that frankly is neither affordable nor accessible, or whether it will force Congress to come back and pass a law that provides accessible and affordable health care. Now, I happen to think Congress has the ability to do so. I know a lot of people, similar to my original comment about post offices, think that they have trouble passing major legislation. But candidly, if the Supreme Court were to say that you really don't have subsidies if you don't have a state exchange, and 37 states have a federal exchange, I think the men and women in Congress understand that that means they actually have to act mature and to pass legislation. And I would be astounded if they didn't. I would, in fact, be very optimistic that they would do their job at risk of being thrown out of office, which is normally the best way that you get folks to do their job. The second case I want to talk about, the second matter is EPA. Now, this isn't a case yet. It will be a case by the end of the year, but it's not a case yet. And that is 111D. So we all hear about the president's alleged war on coal, which is true. But they came forward with a proposal, 111D, which destroys cooperative federalism and says not only, as we're going to tell you where to get in all those areas, coal, gas, nuclear, renewable. We're going to tell you the exact numbers you need to get to, and we're going to tell you exactly how you get there. And what really hurts Georgia more than most states is that Georgia, Tennessee, and South Carolina are in the process for new nuclear. So Georgia ratepayers are responsible for over $14 billion for those new plants. And it's not just Georgia Power. For those that it's MEAG, it's everyone. Oglethorpe, it's several individual systems. Everyone's got money involved in this project. You get zero credit for that project because you did it before they proposed 111D, which is an absolutely atrocious disincentive. You know, for all the time that folks go up to the PSC and the energy industry and say, we don't want you to have to wait for government attacks. We want you to do, quote unquote, the right thing. This is telling the energy industry that if you're stupid enough to do the right thing before you're ordered to do the right thing, you will be punished for doing it. Absolute terrible, terrible lesson. So the next time someone goes up to the energy companies in Georgia and says, you know, you got this plant McDonough in Cobb County right at the Chattahoochee River, and you know it's coal, and the people in Vinings don't like it because they've got all the track used to bring the coal to the plant. And you could spend about $3 billion, and you could double the size of that plant approximately, and you could convert the plant from coal to natural gas, and that would be really good for the environment, and it would be really good for the residents of Vinings because you won't have the track being used so much. The comment is going to be, but we get no credit from the EPA for that $3 billion investment. And under 111D, they do get no credit. Georgia Power does get no credit for that change in Plant McDonough. But once again, that's only $3 billion. We're talking over $14 billion for the under construction nuclear. So we've been spending a lot of energy with EPA in DC to try and change that. Now, when I mentioned Tennessee, Tennessee's sort of a strange animal in that regard because that's TVA. So it's a federal agency. So if the president says you will do something, TVA is going to do it. It's not regular business at that point. So we're spending a lot of time there. Now, some of you are familiar with a legal scholar, Lawrence Tribe. So Lawrence Tribe, I'm sorry, he's Harvard, he's not Columbia. So Lawrence Tribe is a very well-known legal scholar at Harvard Law School. Very liberal, very left. But amazingly, he has written a whole bunch of articles on 111D where he has given, for instance, the following quote. The proposed rule lacks legal basis and represents an improper attempt by EPA unilaterally to remake a vast portion of the American economy. Now, it's not every day we get one of the most noted liberal legal scholars to overtly oppose an action of the EPA. So that tells you how far this administration is going to set their agenda and to potentially finish that agenda this term. So it is a huge, huge case. A corollary, which the EPA is now working on, is waters of the U.S., where many more properties would be subject to the NEPA process and federal permits under EPA. I mean, in essence, you really wouldn't need EPD to be doing that because you'd have EPA doing that. So if you have a big rain and you have water on your property one day a year, you would literally, on a case-by-case basis, need to go up to the EPA for approval before you could build. So by definition, the Farm Reserve Set, Georgia Farm Bureau, Gary Black, the Department of Agriculture, the development industry, I mean, this is a rule that perturbs an awful lot of folks. We are told that we will see significant revision before, God bless you, before it's final, but we're told that on every rule that they propose. And I would anticipate that there will be litigation on that other case, the waters of the U.S. also. Finally, I'll talk a little bit about the immigration case out of Texas that frankly has nothing to do with immigration. You now have 26 states between governors and attorneys general suing the administration in the Southern District of Georgia on the Department of Homeland Security's directive with regard to DACA and DAPA, the children and the parents. Totally usurps the power of Congress. In fact, in the complaint, we specifically said this is not a case about immigration. It is a case about the rule of law. We are a nation of immigrants. My family came from Belarusia, went through Ellis Island. In contrast to many of you, I'm second generation. I get the value of immigration. I especially get the value of legal immigration. We are a nation of laws. We need to act like it. The president on April 20th, 2011, one of his 25 or so times where he apparently misspoke, stated, and I quote, "I can't solve this problem by myself. we're going to have to change the laws in Congress. What happened? His agenda was more important than the rule of law. So on February 16th, federal judge Andrew Hannon granted the injunction we wanted, a preliminary injunction. He didn't get to the constitutional issues. He just simply said, quote, the public interest factor that weighs the heaviest in ensuring the actions of the executive branch is that they comply with this country's laws and Constitution. Now, the Department of Justice's lawyer told the federal judge in Texas that they had not taken any action with regard to the directive because it had not yet gotten to the date where it was supposed to be in force. Well, the administration had to file about 2 weeks ago what they called a defendant's advisory to tell the court that they were wrong, that they misspoke, and that the administration had already begun granting employment authorization to people who came in the country illegally. So the Texas Attorney General, on behalf of the 26 states, filed a motion to file discovery. Because we want to know when these decisions were made, how they were made, and what was occurring potentially during the time that this case was filed as compared to before this case was filed. At the same time, you'll recall the president immediately said he was going to ask the federal judge to stay his injunction. So Judge Hayden said, you know, we're going to have a hearing March 19, so that's tomorrow, and it's only going to be about the administration's misrepresentations. We're not taking up any other issues. And of course, the administration followed that up by going straight to the Fifth Circuit with the appeal of the preliminary injunction. But you need to understand that under the DACA-DAPA directive, it does permit Social Security cards. It does permit driver's licenses. It does permit tax reimbursements. And in many states like Texas, it costs more to issue the license than the cost. And then you have to pay the federal government, I believe, approximately 75 cents per license to comply with Real ID, whereas this is actually working in opposition to Real ID. So it really does cost the states money. And if you get a Georgia driver's license, it isn't for 3 years. So it's very inconsistent with the way states operate. So those are just a couple examples. There's a whole bunch more I could list. I mean, we're pretty active in that space. So I mean, for instance, you've got the disparate impact, the EOC, Operation Chokehold. There's a whole bunch of areas we're looking at and working with our fellow AGs. To me, it's just frustrating at times because the opposition seems to spend all their energy on whether they approve of the policy or disapprove of the policy rather than whether the process is legal. And those same individuals that may be really happy with the president now may be really unhappy with the next president if the next president were to disregard the rule of law too. And you don't want to incentivize disregard of the rule of law. You want the same rules for every administration. You want the same constitution followed for every administration. So shame on us if the next president is a Republican and we don't criticize if that administration seeks to disregard the rule of law. Because the Constitution isn't Republican or Democrat, it's American. And we have an obligation to follow the rule of law in our great country. Happy to take a couple questions before Kelly goes.